And Eric is our, all right, good morning. This is Senate Judiciary, April 4th. Should be April 1st because the snowstorms usually come on April Fool's Day. But this year it's April 4th, and we have Eric Fitzpatrick remote, Senator Baruth and Senator Wachowski are remote, and Senator Sears, Hashim, and Norris are in the committee room. So with that, I'm going to turn it over to Eric, and I don't know how you push the gutted sign, but the gutted sign is up there.
Senator Sheen, can you just press it on the iPad real quick and I'll go right away.
Okay. Because I can't see Eric. There we go. All right. Eric, we're taking up first H 878, enacting miscellaneous judiciary procedures, which truly are a bunch of miscellaneous things that have to do with the judiciary. And it's a yearly bill. This year it's started in the House and it's moving to the Senate. Are you ready?
Yes. Thank you, Senator Sears. Good morning, everybody. As Senator Sears mentioned, the bill I'm walking through this morning is the annual miscellaneous judiciary bill. Each year it rotates as to which body it starts in. Last year it started in the Senate, so this year it started in the House, and so the House passed the version you have in front of you, and now it's with this committee. Senator Sears, I wasn't sure. Do you want me to just walk through it, or do you want to share the screen? Either way is fine, but I just wanted to double check with you.
If you could briefly walk through the highlights of each individual section and
Sure.
what they do.
Yep, sounds good. We'll do. All
And
right.
why
So
they're in there.
I missed that, Senator Sears. Sorry, what was the last?
Okay.
Okay.
Yeah, go ahead.
And why they're in there, he said, Eric.
Why?
Oh, okay, sounds good.
I mean, who asked for court security officers? I assume this was the court administrator and the Judge Zone.
Yes. Yeah, and I can, as I go through each section, I'll definitely mention where they came from and what the source is, that sort of thing. So, and you're exactly right, Senator Sears. The very first section, court security officers, was a request from the court administrator's office in particular. This essentially what it does is it just defines the court administrator's authority over what's called court security officers. You see that on line 7. That's the position. The section provides that the court administrator defines what the duties are of court security officers. Court administrator has direct supervision over them, direct authority, develops a training program. There's a definition for a court security officer over on page 2 at the very top. They are judiciary employed. They shall provide security at court properties and other court-related functions. So that's what they do. There is, there may not be yet, but I think there's a possibility that there will be related language in the big bill that creates funding for court security officer positions. But that is a separate issue. This simply sets out who they are and who has authority over them. So that's the gist of this section.
Any questions
and I'll just keep moving through unless somebody sort of jumps in with a question, if that's okay.
Yeah.
I do actually have a quick question. Eric, are those classified state workers or are they some other type of contract worker? Is that defined in the bill?
It's not. That's a very good question. I don't know the answer, but that would be, see if there's something I can look into, or when you have a witness from the court. But yeah, that's a good point. I don't know the answer.
Okay, thanks.
Yep. Okay. So section.
We should hear from Terry Corsones on this bill.
Yeah, I think that's a good choice, and because there's several recommendations from the court, not just the court administrator, but the chief superior judge as well. One of which is the next section, section 2. This involves it's basically reconciling two conflicting statutes that are related to what happens when a probate judge is either disqualified or can't sit on a case for some reason. Back in 2010, when the Judicial Restructuring Act was passed, a provision was added to statute which provides that in that situation, when a probate judge is disqualified or can't sit, the chief superior judge appoints another probate judge to take that person's case that they can't take. However, didn't realize at the time there was a very old statute on the books that provided that in that situation, which is what you're looking at right now, Section 2, that's a very old statute, as I mentioned, that had said that when there's a conflict, the judge's duties would be performed by somebody, a superior judge assigned by the presiding judge of that unit. That's not done anymore, and it's actually doesn't make any sense anymore because it wouldn't really fit for a superior judge to be taking the duties of a probate judge. That person wouldn't have the experience to do it. So what's the practice that applies now is the one from the Judicial Restructuring Act, which is chief superior judge appoints another probate judge to fill in when a particular probate judge can't handle a case. So, and as I mentioned, that was a request from the chief superior judge to clarify that and repeal the older statutory language that's no longer used anyway. All right, Section 3, purely technical, also basically just making a cross-reference more accurate. You'll see that on top of page 3, line 1, just a more specific cross-reference. Section 4, also purely technical. It just strikes a subheading. You see that in line 5. There was a number of subsections in that section of law that didn't have a subheading, so our editors always note those. Either they all have to have subheadings or none of them do, so we're striking that one. Section 5, this is also a recommendation from the chief superior judge. This has to do with trustee process actions, which is the type of action that if a person wins a lawsuit and they're able to obtain a judgment for money damages, say, or some other relief of that nature, and they have to collect it. The way that you collect it procedurally in court is known as a trustee process action. If you're looking to, collect money or some other property that would satisfy the damage award. So this is it within the chapter on trustee process actions, but it's a statute, again, that's purely archaic. This language is not used at all anymore, completely outdated. And apologies for that phone ringing in the background. Hang on a second.
Everybody wants to be in touch with the post office.
That's right. Yeah, the Ripton sign still is there. All right, so that was the trustee process section. Still moving along, we're up on section 6 now, page 4. This was a request from the Center for Crime Victim Services. So it's basically adding language that's necessary to obtain some federal grant money that evidently is on the table, but we're not able to get it because this federal grant language provides that each state that in order to obtain the grant has to have specific language on the books regarding the rights of sexual assault survivors. So Vermont already has, as you can see in section 6, what's known as the Bill of Rights for Sexual Assault Survivors. This provides that there are certain enumerated rights that sexual assault survivors have. One of those you'll see is on line 15, page 4, the right to receive a medical forensic examination. So that's one of their enumerated statutory rights. And if they opt to exercise that right and get a medical forensic examination, several other rights kick in. And those start on the bottom of page 4, go over onto the top of page 5. Those include, for example, the right to have the sexual assault evidence kit preserved without charge, so the victim isn't charged. Right to be informed about policies governing collection, storage, preservation of the sexual assault evidence kit. And then you'll see the new language, page 5, lines 14 and 15, adds an additional right that a sexual assault survivor would have if they exercise that right with respect to the kit. And that is the right to be informed of the status and location of the sexual assault evidence collection kit. Now that language is very specific. It's tracked on what the Fed grant program requires. So by enacting this language, it will essentially unlock the federal grant money that would be available for the Center for Crime Victim Services and Sexual Assault Survivors. So it's been proposed by them and the language vetted by them. So I think everyone's in agreement that that will do what they need to do to unlock that grant money.
Scott?
Eric,
Yes.
Just a quick question. So when it says they have the right to know the status and location, so the person would go to the local law enforcement agency, the place where they had the contact with police in order to make that request?
I believe that's true, and I also believe that there's a they're able to also get assistance from the Center for Crime Victim Services to sort of point them in the right direction and make the connections that they would need to make to get that kit.
I see, because I've never heard of that, and it seems like
Yeah.
what I have heard of is lots of stories about these kits being warehoused and then lost and unavailable when prosecution eventually occurs. So this is a right for them, but it's also pressure on the law enforcement agency to maintain and maintain order among those kits.
Does the hospital keep them? Or the medical facility?
Yeah, I don't know that. That's a good question too, right?
We'll need to hear from the Center for Crime Victim Services and the network perhaps. Okay, treason. I'm against treason. Why? How this get?
Yeah, sections 7 and 8 are related. They basically repeal the current Vermont statutes on capital punishment. And the idea behind that is that these statutes are unconstitutional. The United States Supreme Court, in a case called, Furman v. Georgia in 1972, declared all state capital punishment statutes unconstitutional. They violated process requirements. And in order to reenact a capital punishment system, which many states did, they had to rewrite their statutes in order to comply with that Furman v. Georgia decision. Vermont never did that. So these Vermont statutes are unconstitutional as they are on the books. The proposal here then is to, and they're sort of out of order in a sense. You'll see that Section 8 is actually the statute that repeals all the capital punishment procedure statutes. And then Section 7 simply makes an amendment to there is one offense, as you mentioned, Senator Sears, treason, that's still on the books that has capital punishment as the penalty. And so it replaces that with, rather than the death penalty of 25 years to life.
How long has our laws regarding capital punishment been unconstitutional? I think it's like 50 years or something.
Yeah, 1972, so 51 years, 52 now.
So why are we now repealing it? Nobody did it for 50 years.
Yeah, I think the concept behind it was that rather than have unconstitutional laws on the books, better to repeal them. Similar to, I think that had been done in the abortion context years ago.
Yeah, I didn't know if there was some group called.
Nope, not that I'm aware of.
Senator Wachowski?
Yeah, Eric, do you know offhand when the last time we actually used our capital punishment laws were?
Yeah,
No.
1950 something. It was a Burlington case, I believe, the 1950s.
So more than 70 years ago?
Over.
Okay.
That there was an electric chair at Windsor. I remember visiting the Windsor prison, and they, even though this was the 1960s when I was first working for the Department of Corrections, visiting the Windsor prison, and they proudly showed us their electric chair.
Wow, how times have changed.
But I believe it was the 1950s. It was, I think his name was Davis or the Mag or something like that.
I could look into. Happy to look into that. It's an interesting question.
Yeah, it's always interesting when we open up laws and seeing how old they are and how they were written from a different time and whether or not we even use them. So I'm just, for context here, thinking about, what are, to be clear, I'm not opposed to eliminating our capital punishment laws. But I think that, when we haven't used something in 70 years, the impact of eliminating it seems less large than if it's something we use pretty regularly.
Right. Yeah, I'll look into that. It's an interesting question.
Who was the last person executed by the state of Vermont? Donald DeMag, 1954.
You know your history.
Yeah, I was right.
Yeah, that was nice memory.
I'm impressed.
Wow, that came out of clear. Donald Edward DeMag was the last person.
And I'm assuming it was not under the treason statute.
It was executed by execution at the Windsor prison for first-degree murder and second-degree murder. A 1948 murder and another one in 1952. Well,
It's like a borderline serial killer.
yeah. So that was the answer to the question.
Thank you.
Cross that one off my list.
Huh?
Ready to move on or? Okay,
Yes,
so,
moving on to service.
yes, section 9. So
This is service of something.
yes,
Not-
service of the extreme risk protection orders, ERPOs. Basically what this is doing here, this is also a request from the court. It's making the process for ERPOs the same as the process for RFAs, relief from abuse orders, that you passed in the miscellaneous bill last year. You may recall the situation was that when an RFA is issued and the defendant was in the courtroom under prior law, even though the defendant was in the courtroom and was given notice of the issuance of the order that way, it was still required that the order be personally served by the sheriff on the defendant. And you guys changed that process last year so that if the defendant was actually in the courtroom and got notice of the order because they were physically present, then there was not a requirement of personal service. And this basically just does the exact same thing with the exact same language for ERPO orders. So if the respondent is there, they don't have to go to the time and expense of personally serving them because they already know about the order. If they're not physically present, yes, they still have to be personally served. But if they're there, they can just mail it to them by first-class mail.
Yeah.
So that was that one.
That's the judiciary, or
I'm sorry, say that again, sir.
is that the judiciary asking for that?
Yes, exactly.
Okay.
Sections 10 and 11 are actually from the Joint Justice Oversight Committee, Senators. I'm sure you'll remember these two sections well. These have to do with S91 last year, Act 28. That was the competency to stand trial insanity defense bill. And remember, one of the things that you passed in that bill provided that when that initial competency evaluation of a criminal defendant is done, Vermont was one of the only two states in the country other than Rhode Island that required it to be done by a psychiatrist. And you expanded that to permit a psychologist trained in forensic psychology, a doctor level psychologist trained in forensic psychology to conduct that initial examination. But it had a 1-year sunset. Remember, so you're going to try it out for a year, and then Justice Oversight would look at it and report back and say, well, is it working? Should we get rid of it, keep it, change it in some way? So Justice Oversight did look at that and reported back that it is working and that it should be kept. So you'll see section 10.
So we're actually repealing sunset, correct?
Exactly. That's how it does.
Eric, I have a quick question. I remember this conversation being pretty in-depth last year about if doctorate level forensic psychologists were the only people other than psychiatrists that were qualified for this. Did Justice Oversight look at whether or not that should be expanded to any other professions?
Yes, I've seen, I don't have the details of it. I only saw the summary of their conclusion, but the conclusion was, for now, keep it at these folks, but not expand it any further at the moment.
Okay, thanks.
Yep.
We looked at a number of other states and we were concerned about expanding it beyond the doctor level psychologist. So we think that we had testimony from a number of people regarding that. We felt comfortable sticking with that particular step. Maybe it's a baby step, and at some point they'll expand it further.
That makes sense.
Okay. Liability for refusal to accept acknowledged power of attorney.
Right, yeah, just to back up 1 second, I skipped section 11, which was related to what I just mentioned, also on page 8. This is related to, also recommended by Justice Oversight. This is just those reports, when they're done by the psychiatrist, there's a statute that provides how they're treated in evidence. They are admitted into evidence and they're considered conclusive on the subject if the parties agree. So here's, in a sense, just a technical change, which was also recommended by Justice Oversight, that the report, if it's done by the psychologist, should be treated in evidence in the same way as the report when it's done by a psychiatrist. So it just adds the reference to the doctoral level psychologist into the statute that provides how their report is treated when it's admitted into evidence.
Okay.
And there's two other sections, page 9, sections 12 and 13, that are purely technical. Section 12 is recommended by the court because it provided the Judicial Bureau with the authority to impose criminal fines and penalties. It isn't done. The Judicial Bureau can't impose criminal fines and penalties, so I'm not sure why that was in statute, but so it's just striking that. It's an erroneous reference. That's section 12. Section 13, also purely technical, just an inaccurate cross-reference that was outdated. So that's something that we noticed in our office. So Budget Council caught that one and we put it in here. All right, the next several sections are all related to, they're all been, I should back up a little bit. They've been recommended by the real estate probate sections of the Vermont Bar, and they, as well as Vermont Title Insurance Company and Vermont Bankers Association have all agreed to much of the language I'm about to mention to you, because it all relates to the act that you passed last year, the Uniform Power of Attorney Act. Remember that? It was Act 60. And now that it's been in effect for a year or so, I think you're about to see there's several places where the practitioners have said there could be some tweaks made to the language that was passed last year. A couple of places that there were a couple of mistakes made, so those are corrected.
Which legislation, Eric? Is this the Uniform Deed Bill or the Uniform?
No, it's called the UPOAA, which is the Uniform Power of Attorney Act.
Oh, okay.
And it was Act 60 last year.
Okay, thank you.
Yeah, sure. And the next several sections I'll deal with this. The first one that's on page 9 starts on the bottom there, section 14. This has to do, you may remember that that Act 60, the Uniform Act, had a model form that people could use. So if they wanted to do a power of attorney, they could just use this model form, makes it, facilitates it for people, makes it more accessible. And then there was a piece of the statute that talked about, if someone acknowledges and executes a power of attorney properly, then it has to be accepted by the person to whom it's presented. The person has to accept it if it's properly done, that the principal is acting on behalf of, that the agent is acting on behalf of the principal. However, that statutory provision only required that it be accepted if they use the form, and the form is optional. You don't have to use the form. You can use it, but you don't have to. Plenty of practitioners prefer to use a form of their own that they've developed, as long as it complies with the statute, it's executed, acknowledged properly. So this section just expands that provision to require that any properly executed or acknowledged power of attorney has to be accepted by the person to whom it's presented, not just if the form is used. So if it's properly executed, it has to be accepted regardless of whether the form is used or not. So that's what's going on in section 14, and makes several changes, all doing that same thing over the next few pages.
Oh, that's most of the rest of the bill.
Well, then we get to page 12, but this, yes, a lot of the bill is related. You'll see this will take us probably halfway through the bill just to talk about this couple more of these power of attorney sections. The next section, section 15, starts on page 12. That goes for a couple of pages too. What this is purely technical. This has to do with when an agent can make a gift of the principal's property. But all that is going on here is that, and you may recall this, that some of the there was a Vermont committee of attorneys and practitioners who developed some changes to the Uniform Act last year. So when they had alternative language they came up with, that was used in place of the uniform language in some places. In this particular section, for some reason, both the language that the Vermont committee came up with and the Uniform Act language were both enacted, which was obviously an error. Whoever drafted this bill, I'll talk to that person and see how they could have made a mistake like that. I really can't understand it.
So the draft is there.
Yes, the drafters. I will talk to
Correct.
him. I will get him to confirm that will never happen again.
Well, after you talk to him and or her,
Right.
figure it out. We look forward to hearing, and we're glad there's a solution.
Right. Yes, thank you. So that's what it does. It strikes the language that was inadvertently included in the first place.
Yeah. Okay. So section 16.
Yep. Starts on page 13. This goes for a long chunk of the bill. This has to do, again, remember I mentioned the model form, and the model form is included in the bill, and that's right here, section 16. Actually, there's two model forms. So this is the first one. This is for the general power of attorney. The second one is for a real estate power of attorney. We'll get to that in a moment. But
there's a lot of forms in here.
Yeah, it's lengthy for sure, but there aren't that many changes. You'll see this is all, in order to make a change, we had to reproduce the whole thing in this section of the bill because it's a model form. It's not amenable to just amending pieces of it in a bill. So it's all here, but there are only a couple of changes made. The main one is over on page 16. So that's the primary difference here. And you'll see that, if you recall this from last year as well, that the way the form was set up, actually both forms, it had a list of powers that the agent under their power of attorney could have. And the agent would decide, that the agent and the principal would decide, but primarily it's up to the principal to make that decision as to whether or not they wanted the agent to have these particular powers or not. But the mechanics, and this is, if you look at page 16, the mechanic, well, if they wanted them to have a particular power, they would check a box. And you see the two parentheses in the bill on lines 10 through 21, each power that they might have, real property, stocks and bonds, et cetera, there's a little box in front of it that they would check if they wanted them to be able to exercise that power. And if they didn't check it, they wouldn't have it. So that means that, basically, it's not included. The power would not be included unless the box was checked or initialed. So actually, it's initial, not check. Sorry. So I think that what was discovered in practice is that was a little harder to follow, and that for people it would be easier to follow to just strike through the ones they don't want the principal to have, the agent to have. So in other words, in this case, the default would be the power is included unless you draw a line through and strike through that particular power. So that's what's being done. You'll see if you look at line 6, instead of saying initial each subject you want them to have, it says strike through each subject you do not want them to have. That's actually the primary change to the form. Not the only one. There are a couple other very technical pieces, but that's the primary change. And that's from 16 over onto page 17. Then one other thing I'll mention over on page 20, that's it's really a technical change. It's just moving the effective date provision. There was some sense that it was easier to follow if it appeared a little bit earlier in the model form. So it's being moved up there, you'll see. That will bring us to the second form, which is on page 24 and 25. This, as I mentioned, there's a specific form for real estate powers of attorney. This is actually one of the pieces that was developed by the Vermont Committee. So the Uniform Act actually doesn't have a particular specific form for real estate transactions, but we had the Vermont Act, Act 60 did have one because the Vermont committee that worked on this developed it. Now the form took the same approach the real estate form took the same approach with respect to checking or initialing the boxes that I just described in the general power of attorney. So in order to be consistent, it's over on page 25, in order to be consistent, the House bill took the same approach, which was to change from an initial to a strike-through approach. However, turns out that, as I say, that was just being done. The House initiated that. And once the practitioners and by that I mean the real estate section of the Vermont Bar Association, Vermont Attorneys Title Company, and the Bankers Association took a look at that, they realized that was actually not going to work with the real estate power of attorney. That in fact, that had to stay the way it was in the existing Act 60 from last year, that because that is a specific list of enumerated powers that would only attach if the person affirmatively chooses to have them by initialing the box, then it should not be crafted so that they would apply automatically unless the person struck through it. So that's a mistake that's being corrected here, and the language was looked at by the VBA, Attorneys Title, and the Bankers Association. My understanding is, actually, let me back up. The language that you're looking at in front of you doesn't have the correction yet. So those folks looked at it. They had some corrective language they've agreed to. I have it. I can put it in an amendment for the committee.
Eric, Senator Norris has a question. Or comment.
Yes, Eric, on page 16, where we have covered this, where it just seems like they just reversed the procedure rather than initial and just striking it. Right. I don't see any place on here where this needs to be witnessed or notarized on this particular form. Am I missing something on this, or is this just something that the attorney does through the individual, or where's the witness or the?
Yes, no, the notary is on page 21, Senator Norris. It's notarization, sort of lines 16 to 20.
Oh, so this extensive process all goes back to that form on 21. We'll notarize for everything that we've just covered then?
Yes, it's a long form, okay. Exactly. All those are parts of the same form.
Separate form. Okay, thank you.
Yep, sure.
Okay. So now we're at grant of authority. Still look like we're in the same section, aren't we?
Yep, and it is the same as the real estate power of attorney, just a technical change to clarify that whatever powers are enumerated here in the form go along with the sort of, in another section of the power of attorney statute, there's incidental powers that are listed. So it's just clarifying that those incidental powers are also included when someone chooses to use this form. And that's it for those sections. I mean, for the form sections. There's a couple of more power of attorney pieces that are over on page 28. Section 18 is the first one. This actually goes to the witnessing piece that Senator Norris was just bringing up, because actually, Senator Norris, although the general power of attorney does need to be witnessed, the real estate power of attorney does not. So when when real estate is transferred, I shouldn't say that. The power of attorney does have to be witnessed, but when real estate is transferred with the power of attorney, it does not require a witness under Act 60. And that's the same under the Uniform Power of Attorney Act. However, there was, similar to what I mentioned earlier in the bill on another subject, there was an older statute that had been on the books for a long time, pre-existing statute, that did require a witness when a power of attorney is used to convey real estate. And in order to reconcile them, make them consistent, that language had to be struck. So that's the older language that you see, line 7 and 8, page 28 is struck to go with the policy in the Uniform Act, which is that when real estate is transferred, witness is not required to a power of attorney.
Thank you. So now going to when parents live separately.
Yes, that there are several sections here that deal with minor changes to the parentage statute. So we're moving out of the power of attorney stuff now into family law, parentage area. That section that you just mentioned, Senator Sears, all that does is update outdated language and references to old statutes that are no longer accurate. So it's purely technical. There's some outdated language, some statutes that are not in effect anymore that are cross-referenced, so those have to be corrected.
I think they passed another bill that had to do with parentage. The House. I don't know if you worked on it or somebody else.
That would have been Michelle. Yeah, it could possibly be. I don't know this for sure, but these sections are from another House bill. So, but I don't know if that's the same one you're thinking of, Senator Sears. I'm not sure.
We have in our committee, I believe we have a Parentage Act bill.
Oh, I think that's separate then, I believe. Yep.
Yeah, so I'm wondering why they're in two different bills.
That's a good question. I will ask Michelle that question as well, just because she works on these subject matters.
Because they were updates to the law required by the feds.
Oh, okay.
And these updates to the law in the same sections. I don't know why. But anyway, that's just something to look at with Michelle.
Yeah.
And if you can coordinate that bill with this bill.
Yes, I will do that. I'll follow up with her.
Can you just repeat what that bill was so I can just reach out to Michelle?
Well, I need to get online and look at my.
I know that these sections of the miscellaneous bill, Ben, came out of H565.
565. Okay.
I don't know what the one is that's in committee right now that Senator Sears was referring to. I'm not sure the number on that one.
Okay.
Well, we were requested by DCF, both Representative Lalonde and I were requested by DCF to do a bill on parentage. And the bill is H745, an act relating to the Vermont Parentage Act.
Okay.
At the very least, we should make sure nothing conflicts in here with that.
Right.
Yeah, I can reach out to Michelle and see if we can get like a meeting with both Eric and her just to kind of coordinate.
Figure out where maybe we should add these to them or the reverse. I don't care. I hate to do two separate bills on the same subject that are technical in nature. I don't believe there's policy in either one.
Yeah, they're not in this one. These are technical, for sure.
All right.
Technical, though, there's a couple of interesting ones, including this next one on the top of page 30, section 21. This is repealing a very archaic statute that dealt with child support requirements, specifically establishing these requirements when a mother of minor children was residing with a man other than the father of the children. So obviously outdated, archaic, and no longer used. So statute is repealed.
Eric, is this bill technical corrections only, or is this a miscellaneous bill where some policy work is done too?
It's the latter. Yep.
Okay.
Yep. So
But it can be policy. I mean, there
right.
have been over the years policy.
Yeah, I was just wondering, I know you said it at the beginning, but I know we do both technical corrections and policies, miscellaneous policies. So I just wanted to make sure my brain was thinking about what we were doing.
Yep, definitely includes both for sure. The next section though is more technical. That's just removing some gender terms and updating some cross references. That's section 22. So making the terms gender neutral, making the cross references current. That's over on page 31 as well. Another correction of a very archaic, outdated statute, section 24, page 31. It's in the divorce laws. It does make it gender neutral. It does that, but also if you look carefully, it's very interesting. It appeared to give the court the discretion, this is line 11, page 31, to decide whether a divorcing woman could resume her prior name. So that was an odd thing that was noticed. So obviously that's a decision for the spouse, not for the court. And so we correct that language there. So that's section 24. Moving on, section 25. This is so that takes us out of that bill. So that H565. That's the end of those sections. Now we're moving on to section 25, which is a request from the court senators here. Section 25 that addresses confidentiality of information that's provided during divorce proceedings. So during divorce proceedings, there's certain types of information that have to be provided. For example, addresses of the parties, current addresses, mailing addresses. If there's a wage withholding order in effect, then information about the employer has to be provided. So there's also an existing statute that says, all right, if there's an RFA in effect, if there's a relief from abuse order in effect, that information has to be confidential. Think about it, it makes sense, because if there's an RFA in effect, then you wouldn't necessarily want the other party knowing the identifying information of addresses, that sort of thing. The statute also provides, though, that that information can be released for good cause shown. That's over page 32, line 12. So the proposal from the court is to say, okay, let's presume that good cause will be established in two circumstances. And those circumstances are, so in other words, the information could be released in these two situations. One, if the relief from abuse order is no longer in effect, so which really just, I think the existing language could be read that way anyway, but it's just clarifying that. So if the RFA is no longer in effect, the information could be released, or if the party consents. So if the party agrees to the release of the information, then that party's own information can be released. Next, so moving on, another request from the court. These are, this is section 26. And this has to do with the procedures when a fake ID is used to obtain a tobacco products. Now, all it does is it's making the procedure for that offense the same as it is under current law for when you use a fake ID to obtain alcohol. And you may remember this because I remember dealing several years ago in this committee with this issue. And then the issue is that if someone does that, if someone uses a fake ID to get alcohol or tobacco, it technically could be covered by both the fake ID statute, or there's a separate statute in Title 23, the motor vehicle statute, that talks about someone using a fake driver's license generally. But the fake ID statute, the committee worked on this, drafted it specifically so that the first offense would have to go to diversion, right? It has to. But that DMV motor vehicle statute doesn't have to go to diversion. So that's what, when you made the correction to the, or not the correction, the clarification to the alcohol statute a few years ago, you said that, look, if someone could be charged under either one of these, they have to be charged under the fake ID statute so that they would have to go to diversion. That was the idea. And this just does the exact same thing for using a fake ID for tobacco as you did for alcohol back then. Does that make sense?
Yep.
All right. Again, it's going to take us through the next several sections. Sections 27 to 34 are all technical language, grammar corrections that I found the committee may remember that every year our Office of Legislative Counsel reissues 4 volumes of the Green Books. So that we work with our publisher in Virginia, we reissue 4 volumes. And if it happens to be one of the volumes that, you know, you as the attorney works on, then that's one of the big projects you have during the summer, which is you have to line by line the entire volume. Last year I got lucky, and Title 27, the real property volume, was reissued. And during the course of that, you know, you notice technical things that need to be fixed. And so that's what the next several sections do. You'll see there's gender neutral language added. There's conjunctions added when they're missing. There's cross references corrected, that sort of thing. Pure technical updates.
And that's all the way to,
Page 37. Yep, section 34.
Eric, why did that not make the big, like 300-page technical corrections bill and get put in here instead?
Yeah, it was just a timing issue.
Okay.
That was all it was, because of the timing of when the publication, it wasn't quite ready. Yep.
All right.
Yeah. We should
Eric?
coordinate that.
More than anything.
Right. Thanks.
Are we on section 35 yet?
We are just exactly there. Yep.
Okay, I am curious about the congregational churches.
Yes. So this is and there are 2 sections, 35 and 36. They're both related. This was a separate House bill, H 646, that got put into the miscellaneous bill. And it actually was drafted and worked on by an attorney in our office, Tucker Anderson, who's now out on family leave. So some of the questions I may not be able to answer, but I can give you the broad background, which is that that it's repealing a statute that's on the books that forced the congregational church, if a particular church was deciding to disband, in order to dispose of any property that the church owned, it forced them to go through this rather cumbersome court process. And the idea here is to essentially rather than require that the church go through this court process, instead just repeal that chapter and allow the local church leaders, parishioners, to decide themselves how they'd want to distribute the assets if they choose to disband. And then my understanding is it was a request from a particular congregational church.
So my question would be, and I have a vague memory of working on this at some point in the recent past.
Right.
I can't remember in what context, but anyway, is it specifically congregational churches, or are other faiths? Why is there specific language around just the congregational church?
It is, interestingly, yes, the chapter, but I believe, and I'll double check this, it is just about congregational churches. That chapter does that, but there may be comparable provisions for other religious faiths that are also on the books. But it was requested, essentially.
Yeah. I'm wondering and this is kind of a professional interest, because I do, in my other life, I do work on, 18th century religions and their manifestations in law and stuff like that. And so I'm wondering if it was, in comparison to the Catholic Church, which is a very hierarchical church where the decisions would be clearly rendered top down, a congregational church is much more empowering the congregation. And so I'm wondering if that was creating problems when they went to sell, where all of a sudden there wasn't the same kind of hardcore statutory hierarchy that you could go to the bishop or whoever, because congregational churches would have a minister, but not necessarily much beyond that in terms of an upper hierarchy. Anyway, any information we can get on that would be great.
Yeah, I think I have a little bit of at least a written summary that kind of responds to some of the issues you're raising with that. And I'll also double check. I think, although I'm not 100% sure, that there are similar provisions on the books for other faiths.
Okay,
But also that, I don't want to misstate it, but when I was reading the summary, I noticed that it did similar to what you just said, it pointed out that the Congregational Church had a particular concern with or at least it was particularly important to them to be able to make their own decisions about this sort of thing. So
Yeah.
maybe that's where the request came from in particular.
Yeah.
But
Okay.
I'll follow up on that too.
yeah, just personal curiosity.
Yeah. So that's what that does. And then section 36 is related in that it's just making clear that by repealing that chapter, it's not infringing on any First Amendment rights or religious free exercise rights of the Congregational Church or anybody else. So that brings us to sections 37 and 38, I believe, are connected. This is a request. These both sections are requests from the Center for Crime Victim Services. And these involve Act 40 last year, which you may recall established this Coordinated Justice Reform Advisory Council. So that was created last year in Act 40. The idea of the council was to support state and local restorative justice programs to kind of coordinate and attempt to make sure that things are consistent and uniform where appropriate. And one thing that the council does annually is recommend to the Commissioner of Corrections not more than $900,000 from the Justice Reinvestment 2 line item in the DOC's budget to support those community-based programs. So that's one of the functions of this council. So what this proposal then is doing is clarifying that recommendation, that $900,000 or not more than $900,000 is for the next fiscal year. And you'll see that's line 13, page 38. Just clarifying that so that it's clear that the council would have time to make the recommendation in advance for how that money would be spent on the community-based programs.
Yeah, Senator Norris has a question, and I do after his question.
Thank you. I'm not quite sure this is for you, Eric, or for Senator Sears in reference to the $900,000. Is it my understanding that $900,000 still remains there and was not allocated from September of last year? Or?
No, it was, but the confusion comes in. The agencies that get supported it got messed up this year because the Department of Corrections in its base budget for the programs supporting the network against domestic violence and sexual assault and diversion indicated that they hadn't cut their budgets, but diversion specifically saw what they thought was a $900,000 cut in their base because justice reinvestment wasn't included. So, and the Department of Corrections sees it as one-time money, and we've got a mess to deal with, like in everything else lately. And so this is an effort, I think, to try to get make it clear that the proposal from the Coordinated Justice Council to the Commissioner of Corrections, and I don't know why 900,000, by the way. Could be any amount. We should be looking at all the justice reinvestment funds, I think, but we can talk about that when we mark the bill up. But it's basically, that's the problem, and that's why we're trying to get it done earlier, because we still haven't made the allocation, to my knowledge. There may have been a recent meeting. So it's confusing at best when you get into the budget side of it. And this will help, I think, help clarify.
Thank you.
And as I say, both the two sections in a row are related. Section 38, similar, just making clear that those recommendations that you're mentioning, Senator Sears, But for the next subsequent fiscal year, those recommendations would have to be in the budget. So similar idea. And also providing there that the council has to include in its annual reports any efforts it has made to consult with other interested parties on those recommendations for community-based groups. So that brings us to sections 39 and 40. A good chunk of the rest of the bill starts on the bottom of page 39. These two sections reenact language that was inadvertently repealed last year in a separate bill known as Act 53. It wasn't a bill that was in this committee, but it was a bill, that I believe it was from the Senate GovOps, that repealed a bunch of boards and commissions that were no longer used. And so it was a large bill that was repealing a number of different boards and commissions. And one of those was what's known as the Natural Gas and Oil Resources Board. So that was one of the boards that was repealed in Act 53. However, embedded within the Natural Gas and Resources Board statute, unbeknownst to other people who, because the language was quite lengthy, I didn't notice it, is a provision that involves a accelerated court procedure for essentially removing abandoned leases that are on property, abandoned oil and natural gas leases. And the reason that process exists in law, it's an interesting historical story, but 100 years ago, a little bit less, but in that neighborhood, their oil and gas leases were sold by property owners in Vermont to large companies because on the idea that, who knows, there might be oil and gas underneath those properties, and you could make a little bit of money by selling the lease rights to these companies. Turned out that there was not a huge run on gas and oil under Vermont property. So, but those leases are still there. They're still on the chain of title. And that's the problem, is that in many properties, when title searches are done by real estate attorneys, they come upon these old leases that are no longer, actually, technically, they could go to court. And this is why that separate provision was in the law. You could go to court, a rather lengthy, cumbersome process, have a court issue an order that it was abandoned, that the lease had been abandoned, which is the case. It's been on the books for all these years. But because there were so many years ago, this accelerated specific court process was created so that people could go in, and real estate attorneys found these things. They could do this quick process, boom, 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 they get the lease released. And that way they can provide clear title if you want to buy land in Vermont or sell it. That was been the problem. The title companies couldn't certify clean title because these leases were still out there. So that convenient process hasn't been used since July 1st of last year because it was inadvertently repealed. So it was noticed by the real estate section of the Bar Association. They brought it to our attention, by the Vermont Attorneys Title Corporation as well. They brought it to my attention, actually. And so we passed it along and to the chair of Senate GovOps, and that's where this comes from. So it's just, all it does is verbatim reenact the statute that was on the books prior to Act 40 last year. No changes at all.
Okay.
All right, that brings us to, we're essentially, we're right at the end. Well, actually, almost at the end.
What are we,
We're
we're deleting
page 4.
stuff,
Go ahead, sorry, Senator Sears.
section 42? Is
Yes,
that where we are?
Yep, 41 and 42 are related. This repeals the sunset on permitting gun suppressors while hunting. Remember,
Okay.
so you have something in law right now that permits gun suppressors to be used by hunting, but it has a sunset. And that sunset is
Yes,
this
I
year,
remember.
July 1st, 2024. And this
Clearly-
repeals that so that suppressors would be allowed for use while hunting going forward.
Yes. I remember that.
Yep.
I do too. And I'm I guess what I would say is I'm tentatively in favor of it. I would like to take a little testimony just to understand what, if any, changes have happened since we put it into law. One of my initial concerns was that it was, maybe a paranoid concern was that it was some kind of stalking horse for using more suppressors in more areas than would have been immediately apparent. But I liked the fact that it reduced some of the complaints around people who live near hunting areas and were bothered by shooting. So, Senator Sears, if it's all right, if we could have some testimony on that section.
Sure.
Just to
You
make
could
sure.
just let Ben know who you'd like to hear.
Maybe Chris Bradley, and
Yep.
then I'll think about who might represent the other side of that.
Yeah,
Eric Davis or
okay.
Could you just remind me what section this was?
42.
Section 42. Sounds
And
good.
41 also.
Excuse me, 41 and 42.
Yep.
I didn't realize 41 deleted, it just said deleted, so
Right.
I
Right.
deleted Eric.
Yeah, Senator Booth, if you just send me when this is, as you come up with them, I will put that
Yeah,
together.
whenever we take it up next, obviously, we're gonna have the court and Chris Delia and the probate person and et cetera. But we should include somebody on this. And on section 43, I'm fine with that. I talked to that it's been generally agreed that it didn't help.
That
So
pilot
it's-
project.
Yeah.
Yeah.
But
And it just
now,
repeals it.
drones is a different matter.
Yes. This is a sections
Ken?
44 to 45 were actually
Isn't-
H284 was a bill that didn't make crossover in the House. So it did pass House Judiciary, but it didn't make crossover. So it was included miscellaneous bill. That's why it's here.
Can we do this constitutionally?
Yes, I think
Let the
constitutionally,
let the federal government control drones.
not
and
entirely. There's obviously whether to do it's a policy decision for you. But yes, I did actually consult with the preemption attorney at the Federal Aviation Administration while the bill was in the House and ran the language by him. And he was of the opinion that this was permissible. And the reason being that, the feds, there's sort of concurrent authority, joint authority over drones. The feds control some, they control everything from 400 feet above and above that's federal airspace. But below that, there's some concurrent authority. And there's some areas in which the state can regulate, and those involve, like, for example, privacy in particular. You see, that's kind of what's being addressed here. So that's why he thought that it probably was going to be okay.
Senator Hashim and then Senator Bowski have comments or questions.
Eric, did you say that the max was 400 feet?
I thought it was 80.
400 for exclusive federal regulation. Yes, below 400, the state has some ability to regulate.
I mean, I'd be open to having that number be higher than 100 feet personally, but open to discussion for that one.
Senator Bowski.
Yeah, this is the section on drone surveillance. Yes.
Yes.
Okay. I think it would be important, and Senator Shears, it might have been in your district and I know we can't regulate airplane stalking, but I do think that this is a space where we may be talking about stalking, and it would probably be good to hear from the network.
Yes, well, actually, you can regulate stalking by airplane. The concern is the stalking actually occurred in New York State, not in Bennington County, but the plane flew from Bennington over to another location in New York State where the person who worked at a certain diner or restaurant was being stalked. And the plane would have signs and, I'm looking at you, blah, blah, blah. then after he was taken to court, he flew off in his airplane, which is risk of flight.
Yeah, I would say that that is quite literally a risk of flight.
Yeah, yes. Senator Norris.
Yes, in looking at this, and I agree that there should be expectation of privacy for everyone here in the state of Vermont. And I see they get this nice little addition here along with nice little fines that go along with it. But from a local standpoint, how do you expect local law enforcement to enforce this?
Well, who's running the drone?
Exactly.
Is it Google? Is it Google?
I don't know. I'm saying, how do you expect local law enforcement to enforce this? Unless I
Doing
actually
investigation.
discharge
I've
something, bring it
done-
down in front of me here, but I mean,
That's.
I've done Google, a Google Maps, and I've seen my house.
but they're talking about physically flying a drone over somebody's property, correct?
Yeah,
Well, I mean, if you do an investigation and you gather evidence that identifies who the owner of the drone is and why they're flying it, then you have a case. And if
Yeah,
you
that's
can't
right.
identify the owner, then you don't have
You
a
don't have a
case.
case.
Right.
And there's
Like-
probably a high probability
just like
that you'll
any
never be able
other-
to identify. All I'm
and how do
saying
you
is,
know it's 100 feet or more?
exactly, this is, it looks good on paper and I agree with it, but I don't know how we're gonna enforce it.
Anyhow, we'll go through markup of the bill. Senator, Wahowski has, mentioned, there is I believe somebody in the House contacted Senator Baruth about the issue of stalking and using
Yeah.
drones.
If I could, I just wanted to briefly bring that in. So Representative Black in the House has, for the last couple of years, put in a bill about trail cams, where people will install a camera on a tree in the forest and they watch in real time wildlife. But apparently she knows at least one case where, a disgruntled partner was putting one of these cameras on someone else's property to surveil them. And so it seems a similar thing to the drone, except it's easier to find and prosecute, I would think.
Yeah. It's a stable camera.
Yeah.
All right, so this one's gonna take a little more discussion. And,
And I can, Eric, I don't know if you have Representative Black's language. It's been submitted a couple of times.
I don't, but I can look into it. Trail cams, you say?
Yes.
Okay.
And, it seems to me that somebody putting any kind of camera on somebody else's property should be immediately illegal.
I would think that would be a trespass on property in the first place.
Yeah, sure.
Yeah.
But yeah, I guess if somebody put a camera next to somebody else's property, sort of surveilling them, that would be
Right.
So,
Yeah, that's different because you wouldn't act, if the camera wasn't on their property, it probably wouldn't be a trespass necessarily.
but if you live in close proximity to the other house, and your house happens to be in their field of play, I don't know, we can talk about this certainly, when we get to markup of the bill. Are there any other sections, Eric?
Nope, that's it. That's the effective date is on passage and that's it.
Okay, there's section 45, Judicial Bureau. Jurisdiction.
That's connected to the drones because the drone is a civil offense. So it's just amending the
Okay.
Judicial Bureau so they can hear those drone civil violations.
And I have an amendment already, that I think I've talked to some of you about. I certainly have talked to Senator Baruch and Senator Kitchell and Senator Cummings and Representative Lalonde. And this has to do with, the life estate deeds that we put together a few years back. And, when I went to do my life estate deed so I could avoid probate, I was told that I had to come up with $1,300 and something, or the person on my life estate deed had to do that. I said, well, wait a minute, I haven't decided whether I might sell my house or do anything else with it. This is just, you know, if I pass away, to make sure that it goes to the right person. And so the tax department had decided that once you execute the deed, you had to make the payment of the property transfer tax immediately. And this amendment just says you do that after you die and the property's actually transferred, because a lot of people change their minds, do something else. You know, the other day when I was doing my property taxes, I yelled and said, I'm moving to Bon Air. Excuse me, my income taxes. I said to my son, that's it, we're moving from Vermont, we're going to Bon Air. Sell the house. So if I decided to sell the house, and I had the life estate deed, then I'd have a hard time getting back my, whatever I paid for the property transfer tax. But no property's been transferred until you pass away. So that's what this does.
Yep,
And that's
exactly it.
Our intent was that any taxes be paid at the time that the person passes away and the property is actually transferred.
Yep, that's right. Because the property with a life estate deed doesn't actually get transferred until the person passes away. So it's sort of, as you mentioned, Senators, here seems sort of odd that the tax would be due immediately if the transfer, you know, person could change their mind. It might never happen.
My lawyer told me that about 5 people that or 3 people, excuse me, 2 or 3 people that he's dealt with all decided not to do the life estate deed as a result of the property transfer tax being due.
Huh.
So we want people to do this. We don't want them to not do it. Anyhow, that's it for now for the miscellaneous bill. I'm sure there'll be other amendments that committee members may want to consider, and I'm open to either policy or technical amendments.
Yeah, I think this might be a great tool to maybe get to some of the smaller things that we didn't quite have time for before crossover. And I'm happy to connect with you, Senator Shears, and talk about some of the things I've got in mind.
Okay. All right. Well, we're going to can we take a 10-minute break?